Good morning. I'm Liz Loadholt, better known to most of you as Mama Liz. And today we're going to talk about contract pitfalls. Some of the things that you need to watch out for when you are writing contracts and also when you are going from contract to closing. Some general things that you need to remember is, first of all, be sure to put in the legal names in which the buyers intend to hold the title to the property. For example, maybe you're working with Jimmy and Sarah Lee. Well, Jimmy is probably not his real legal name. More than likely it's James. So the attorneys really appreciate it when you put the legal names in the contract. That's what's supposed to go there. If you have two or more people who are buyers, each of them must sign the contract and the addendum. Now that seems like common sense, doesn't it? But you'd be surprised how many times that doesn't happen. Another thing is all blanks in a contract should have something in them. Do not leave a blank on a contract. Now, the contract forms were designed by the State of South Carolina Association of Realtors so that we could have a legal document that we could use without practicing law. They left the blanks, and we can legally fill in those blanks, but they're there for a reason. Fill them in. You might say, well, I don't have anything to put in that blank. Then what do you put there? You're right, NA. Put something in the blanks. Anytime there's a change, it must be initialed and dated by each of the parties to the contract. It must be initialed and dated by each of the parties to the contract. Oh, guys, I can't tell you how many times, how many contracts I've seen where this is not done. You assume you have a ratified contract, but all the initials, all the changes have not been initialed and dated. And believe me, the date can become very, very important. If it ends up in a lawsuit, dates are critical. You never know when your contract is going to end up in a lawsuit. So, somebody says, tell Ute to click use mic and speaker. So hopefully that works, Ute. You need to put this, get those initials, the changes initialed and dated. Very, very important. I've been involved in lawsuits where this was critical. It wasn't done, and we ended up spending lots of money. And the agent owner ended up spending the deductible for E&O insurance, which is $5,000 is your share. The company pays an additional $10,000. So we don't want to go there. We don't want to go there and do that. Believe me, people sue us for enough reasons as it is. They may not like the color of your hair, but we don't need to give them other reasons and make their life any easier. You must have a date for the closing date. For example, September 1st, 2011. Not within 30 days after the home inspection or within 30 days after the due diligence or whatever. South Carolina law says that you must have a specific date in your contract to make it enforceable. Verbal contracts are not legal in South Carolina. Okay, somebody's writing me a question. I'm sorry. Should you ever state subject to satisfactory home inspection? I'm going to get to that, Yvonne. Thank you. Verbal contracts are not legal in South Carolina. I don't care what people tell you. They're not legal. So, when you're negotiating a contract, so often another agent from another company will say to you, oh, let's just go back and forth verbally until we can reach an agreement, and then we'll put it in writing. Well, I guess that's okay, as long as your seller or your buyer, whomever you're representing, understands that this is not legal and it's not binding. Just because they come to some verbal agreement doesn't mean that it's going to be binding. And it doesn't mean that when they written document appears, that person's really going to sign it for that amount. So if you get into verbal situations, be very careful. It cost us a lot of money one time because of the same situation. We had a situation where an agent owner, they went back and forth verbally, and the buyer was from New Jersey, I believe, and the agent owner told the buyer, "We got a deal. We've got a deal. We'll get it signed tomorrow and get it to you." Well, by the time that her buyer signed that offer and got it to the listing agent had gotten another offer which was better, and the seller chose to accept the larger, better offer. So we were in a mess. Verbal contracts are not legal in South Carolina. Do not get involved in verbal contracts. Never give possession prior to closing or after closing. Now, this is a Mama Liz rule. You can get yourself in serious problems, serious trouble with that. The nicest people in the world will become unnice. They will find every reason in the world, if they've moved in prior to closing, every reason in the world not to close. So Mama Liz says, don't let them move in before closing, or let them stay in after closing. And if you have to do that, then talk to your broker. Get advice from your broker, because there are some times when you have to do this. Now, I have another question I see. What if both buyers are not on the mortgage but married? Do both buyers still sign the contract? If you've got two buyers, yes. If there are two buyers or three buyers, then two or three, each of the buyers has to sign the contract. Doesn't matter about the mortgage, but sometimes the lender may say, I don't want them on the contract. Maybe you have to redo the contract. But if two names are on the contract, then yes, they both have to sign. Addendum A. Some of you may be saying, Addendum A? What is Addendum A? Addendum A is an addendum that we have over the years put together. It is 4 pages long, but it has a lot of different things in that addendum that remind you of things to ask for your buyer when you're writing an offer. This is for buyers. This is not for sellers, this Addendum A. Things, for example, like making sure that the buyers have an opportunity to see the covenants and restrictions ahead of time before closing. This is critical. There are a lot of things in this Addendum A that you need to be using. So Mama Liz says, if you're with agent-owned realty and you're writing an offer on a property, you should use the Addendum A along with it. Always check the following boxes on your Addendum A: the restricted covenants, the seller's property disclosure, existing termite bond, meaning that if they have a termite bond, the buyer would like to get it. Title insurance. If the seller has a title insurance policy that is less than 10 years old, then your buyer wants it so that they can get reissue credit. The survey and elevation certificate. If the seller has a current survey and elevation certificate, then your buyer would like to get that. That could save them some money when they're getting their flood insurance, for example. The home inspection approval at sole discretion of the buyer. Yvonne, this goes back to your question. I think this is critical. If you are representing a buyer, not a seller, but if you're representing the buyer, you need to make your contract or your offer subject to the home inspection approval at the sole discretion of the buyer. The verbiage for this is in the Addendum A. For those of you who do not have access to Addendum A, just email me and I will get it to you. If I email it to you, it is in a Word document so that you can cut and paste. You don't have to use all 4 pages if you don't want, because it does seem overwhelming sometimes. You can cut and paste. The home inspection clause. Some of you are saying, well, why do I need to do the home inspection clause in the addendum? Because it is already in the contract. Well, in the addendum, we go into more detail and we go further. The mortgage, if they're obtaining a mortgage, items to remain with the property, and this items to remain with the property gets sticky in today's world, financial world. Most mortgage companies do not want you to put these things in the contract, even the addendum. They want you to do these with a separate bill of sale. So here, if you're doing it with a separate bill of sale, then you just address that in this part of the addendum. Just saying all items in the separate bill of sale go with the property. The walkthrough inspection. Now, you would think it goes without saying that all buyers want to do a walkthrough inspection. Not all buyers want to do it. They feel like they're rushed, they don't have time. It is your job as a realtor who is representing that buyer to recommend that they do have the walkthrough. You want to do the walkthrough not 2 days before, hopefully not even the day before, and not before the furniture is moved out of the house. Preferably the walkthrough inspection is done the morning of the closing. Sometimes the day before if the people are already out. But the important thing is to have the sellers out of the property when you do that walkthrough. It's amazing what can be found when the house gets vacated. Any risk of loss of damage. This is kind of repeating what's in the contract. Today's contract is written much better about this, so we don't have to worry so much about this in the addendum. Homeowners insurance, especially along the coast here in the Charleston, Tri-County area, Myrtle Beach area. This is very important that your buyers get their homeowners insurance immediately after the contract is ratified. Homeowners insurance is hard to get, as most people know, on the coast. Critical that you take care of this when the contract is being offered. This addendum is making the contract contingent upon the buyer obtaining satisfactory homeowners insurance. Remember, this addendum is written to protect your buyers. The homeowners association, if there is one, then we want to find out what the fees are and things like that. And it's nice to put the closing attorney in the offer. That helps you get the buyer to go ahead and select the attorney, and hopefully one of the attorneys on our alliance list that has agreed to work with agent-owned realty so that your company writes the title insurance. And on the Addendum A, there's a block about taxes and square footage. Always have your buyer read it and initial and date that, stating that they have read it. Earnest money. Some of you might think earnest money is required to have an enforceable ratified contract. It is not, but most sellers want earnest money. So earnest money, I think our contract should have some sort of earnest money. And my guide to how much, and everybody would have a different idea on this, I'm sure. This just happens to be Mama Liz's guide. Between $50,000 and $100,000, I think at least $1,000. $100,000 to $500,000, between $3,000 and $5,000. $500,000 plus, I say $5,000 or 10%. However, be careful. Small claims court maximum is $7,500. So I recommend not going over $7,500 for earnest money. Now, why? If there's a dispute over the earnest money and buyers and sellers cannot agree who's going to get it, you have to go to court, small claims court. If it's under $7,500, if not, you got to go to the big courts. That takes forever. So if you explain this properly to your sellers and your buyers, then they most of the time will understand and go along with that maximum. You can use a promise to pay for earnest money. For example, you can write in there earnest money to be paid by a certain date. Now, if you do that and the contract gets ratified that way, you must keep up with that date and make sure you get that earnest money by that date. If you don't, then your contract is no good. And I'm going to give an example here. Now, the next big item that we have, subject to financing clause. And the subject to financing clause is a real problem to me. I have talked with the state several times. I've asked the state of South Carolina to please help me with this. I think it's terrible, but they say the contract is good the way it is written and that it's written for the protection of the seller. I disagree with that. However, that's my choice to disagree. And so since I'm disagreeing, I feel it's my responsibility to let you, my agent owners, know how I feel about it and how I feel it can be corrected. This is the loan financing paragraph in your subject to financing contracts. And it states up here, the buyer is contingent upon the buyer obtaining said loan shall apply for a maximum of what percent loan, 80%, 90%, whatever, loan to value within blank consecutive days from the execution of this agreement, and shall provide seller with written satisfactory loan approval within blank consecutive days that contains no credit, income, or asset conditions unless otherwise set forth in this contract. That is a mouthful. And anybody who's done a lot of mortgages knows you cannot get loan approval that contains no credit, income, or asset conditions until closing or right at closing, unless you've got extremely strong buyers. So 99.99% of the time, you're not going to be able to get this loan approval with no credit, income, or asset conditions. So if you fill out this contract and you just put, say, 15 days in here, what's going to happen? Maybe nothing. Maybe you get to closing and it all goes smoothly. One of my favorite sayings in the world is, nothing's a problem until it's a problem. Okay, you may go to closing, everything's great, smooth, but you may have major problems. This would make your contract voidable. So let's look at some possible ways that we might change it. Here's one way that I can suggest. The buyer shall apply for a maximum 90% of whatever the loan to value is within 5 consecutive days, and that really doesn't matter so much because most of the time your loan app is done right after the contract, or a lot of times before the contract's written. Satisfactory loan approval, and strike out the word at within and put at closing and strike out consecutive days, because that is when you're going to get a loan approval with no contingencies, is at closing. Be sure and have that change initialed and dated by your buyers, and then it has to be initialed and dated by the sellers as well. Now, you're saying to yourself, she's crazy. A seller's not going to go along with that. They're not going to accept my offer if I put that in there. Maybe true. Let's look at another way. This is a way, and you can tell by the dates here that this was really, samples were done back in 06, 05, and 06. But the closing date on this particular contract, we say, is September the 20th, 2006. So knowing that, we put in here, we strike out the word within, and we put the date, the closing date, instead of the words at closing, and strike out consecutive days. Remember to be sure to have them initial and dated. Now you're saying, well, that might fool the seller. That might work. Well, if you do this, you better be careful. If the closing date gets extended, you better come in and extend this date as well. Okay? Let's look at another way, because the seller may not, and the listing agent may not like this either. Another way would be to put in pre-loan approval, satisfactory pre-loan approval, and put whatever days you want. Doesn't matter, because most of the time you're going to get pre-approval before the offer is written anyway. And here we're still saying it contains no credit, income, or asset conditions. Okay, real life, do you ever get a pre-approval letter that doesn't contain some kind of condition? Very, very rare. Actually, I don't know that I've ever seen one. Most all of them are subject to a final verification of credit, or maybe verification of credit, verification of income, verification that everything that they've been told is true. So, knowing that's the case, if you really want to protect yourself, we need to put pre-approval, you need to strike this out. This is the way that most people prefer to do it, and this is the one that gets by the easiest usually. So you do whatever suits you, whatever fits your listing agent. And if you are representing a seller, for example, and you get an offer from another agent, from another company, because all agent owners know how to fix this, and they don't have anything done, and that would be the only change that you need to make on the contract, for goodness sakes, don't mess with it if that's the only change. But as you explain the reasons why you're messing with this, people understand. It makes you have an enforceable contract. Okay? Another way is to put in there, is to put in 15 consecutive days and then strike out no credit, income, asset conditions. That works as well, because you can get a loan approval that's going to have conditions, but you can get that probably in the 15 or 20 days, whatever you put in there. So you decide what works best for your situation. Now, this financing contract, a clause, also has in there, buyer further gives permission to the lender to disclose pertinent information concerning the buyer's creditworthiness or any other information needed for the loan processing to the listing or cooperating brokers or agents. How many times have you had a lender tell you that they can't disclose the financial information of the buyer you're representing the seller because that's privacy? You tell them that the contract you have gives them permission to do that. Make sure that they understand it. I've had it before. Cut this out, paste it, and email it to attorneys, lenders, and to other agents to make them realize that their buyers have already signed permission for this. Just want to bring that to your attention. If the buyer, this is also in that paragraph, if the buyer fails to comply with these above conditions, the buyer shall be in default of this agreement, subject to the terms of paragraph 16 of this agreement. So if you put some crazy stuff in here that can't be met, here you go. The extension agreement. This is another hot button of mine, if you will. It says if this transaction has not closed within the stipulated time limit because a contingency has not been satisfied through no fault of either party. No fault of either party. That doesn't mean that if the buyer just can't get everything, all their ducks lined up in a row and they can't get moved down here by the closing date, they need to extend it. And that's the fault of the buyer. It doesn't mean that if the seller can't get the repairs done in time, it doesn't fit here. That is a fault of the seller. All this paragraph is talking about, guys, is if the lender has a problem if the attorney has a problem, if there's something that's outside of the scope and reach of the buyer and seller. That's all this applies to. This is not an automatic extension of the closing date. Okay? It's not. It is not an automatic extension of the closing date. You have so many realtors out there in the field that assume it's just an automatic extension. I want you, my agent owners, to be smarter than them. It is not. And usually 5 to 10 days is plenty of time for this if you're representing the seller. There's no need to give 30 days. There's just no need to give that. Okay? If we're representing the buyer, you may want to put longer in there, but really it's just holding up the closing process for you and everybody else, because it only can come into play if there's a problem from the lender or the attorney or someone other than the buyer and the seller. Put myself back up. It can go longer if you're representing the buyer, as I just said. Now, paragraph 16 is a default clause of the contract. And this doesn't come into play so much in today's market as when the market is really bustling and you're getting multiple offers on contracts, but it is still something you need to know and be aware of and understand. It says, if the buyer or seller fails to perform any covenant of this agreement, the other may elect to seek any remedy provided by law, including blah, 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 or terminate this agreement with a 5-day written notice. Not both, either or. So if you have a seller that wants to get out of the contract for some reason and the buyer has failed to meet some contingency in the contract, then they can use this. If the seller wants just to get the contract closed, they can give 5-day written notice that they're going to terminate the contract if this condition is not met. And that, when that 5 days is over, the contract is dead. And the buyers do get their earnest money back in that case. Now, if the seller wants to try and get damages and all of the things that he may be entitled to, he cannot do that. He has to go the other route, which is the first part of this paragraph. So either or, okay? The condition of the property. This is another issue that is misunderstood, believe it or not, by a lot of real estate agents. If the buyer and seller agree not to have a seller's property condition disclosure statement completed, then it's okay not to have one. That's why the block is on the contract. But if you're representing a buyer, it is not in the buyer's best interest to not get a property disclosure statement. However, if it is checked, then it's okay not to have it, according to state law. Then you would check that first block. But again, you're representing the buyer. Please don't do that. Now, your inspection. This is another one really misunderstood. The buyer's expense shall, let me try something here. Hope I don't mess up. No, oh well. The buyer's expense shall, in the event repairs are necessary to place the heating system, air conditioning, and the dwelling structurally sound, the seller shall be notified in writing of those within 48 hours after the inspection date mentioned above. It's not 48 hours after the inspection is done. It's 48 hours after the date that you've put in the contract. Now, time is of the essence. The next sentence is extremely critical, guys. If the buyer fails to notify the seller within this time frame that you have put in the contract, the buyer shall have waived any and all rights to a home inspection. So if you have a contract and you're going from contract to closing, pending to closing, you need to watch out for all the dates and things that are in your contract. Do not let this inspection date pass if you're representing that buyer, because if you do, then it's up to the goodness of the seller whether or not they will listen to the repair request from the buyer. Very important. Lisa Donahoe wants to know if there's a form that we can use for the release of contract. Are you speaking about giving the 5-day written notice? I'm assuming that's what you're asking. And there's no real form for it, but I have written letters for that. So I'll be glad to send those to anybody that sends me an email and request it. You can just change the property address and that kind of information. Okay? Regarding the inspection, let's talk about the wood infestation report. We have a similar clause in this. If you're representing the buyer, you probably want the buyer to obtain the CL 100 letter. They can choose the inspector of their choice then. Be careful about the date you put in the blank if this is the case. If the buyer is responsible for having the CL 100 letter done, as indicated in the contract, but fails to do it by the date that you put there, buyer shall have waived all rights. Did you realize that was there? Many of you, maybe you do. If you've really read this contract like all of us should, you probably know it's there. But probably most of you forget about that. Be careful, because again, if you put a date in there and your buyer does not do it by that date, they have waived their rights to have the CL 100 letter and have the repairs done. Okay? If the inspection report reveals presence or damage by blank blank, the seller shall remedy such deficiencies subject to Section E below. What is Section E? Repairs. I have had very experienced realtors try to argue with me that the contract says that the seller will repair heating, air conditioning, the things that are listed in your contract specifically, that they must repair those things. If you continue in your contract and go to paragraph E, which addresses repairs, you'll see that's not the case. The cost of all repairs to heating, air conditioning, and blah, 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 and make the structure structurally sound and provide wood infestation treatments, if any, required by Section B and D above, to be paid by the seller. Okay? We got to go further. If the seller refuses to make these repairs and treatment, the buyer shall have the option to 1. Accept the property as it is in its present condition. 2. Negotiate with the seller for payment of the repairs and treatment. Or 3. Terminate this agreement subject to paragraph 7, which is the earnest money clause, and they would get their earnest money back. So the seller is not required to do repairs, okay? If they refuse, then the buyer can buy it as is, negotiate with the seller, or terminate the contract. Let's talk about contingencies. The contingency part of your contract is a blank, and you should always add the following verbiage to that blank. See attached Addendum A, which shall be considered an integral part of this contract. Now, that's assuming that you're using our Addendum A. You can't just have Addendum A sitting there unless you reference it in your contract. Well, you can, but it's not going to be legal and binding. It needs to be referenced in your contract, so then it becomes a part of your contract. Okay? This is the verbiage that you need to put there. Or at least you need to put, see attached Addendum A. The first is, this verbiage is better, but this will work. You need to put something in there. And this, then you let your Addendum A take care of all of these other contingencies that your buyer needs to put in the offer to purchase. Signatures and witnesses. Oh, wow. This seems like a no-brainer. Please do not sign as a witness on your contract or offer unless you actually see the person sign, okay? I could tell you, I have several horror stories about this. One in particular that comes to mind, I had an agent owner that was anxious to, in her mind, she thought the seller's signatures had to be witnessed. So she witnessed the seller's signatures when she did not actually see a seller sign. Actually, the sellers were in New Jersey at the time they signed. She was in Charleston. Okay, how did she witness that? I don't know. Maybe by Skype or something. But, you know, that is an idea. Actually, I hadn't thought of that before. Okay, but in this case, Skype wasn't there. And it got to closing, and it came up that something was supposed to be left. The drapes were supposed to be left. And the wife removed them. And when it came to the issue in the closing table, the attorney said to the seller, to the wife, you signed the contract. You can't take that drapery out of the house. She said, I never signed that contract. So he turns to the real estate agent and says, the realtor, and says, you witnessed it. And she had egg on her face. She had to say, no, sir, I did not witness the actual signing of the contract. Now, how embarrassing is that? And guess who bought those drapery? And they were not cheap. You're right, the realtor. Be careful. If you don't actually see somebody sign something, don't witness it. Yes, the law in South Carolina says that the contract should be witnessed, the signatures should be witnessed. But I've talked to dozens and dozens of attorneys who will tell you it's not required to have an enforceable contract. Okay? Another thing, I'm talking about that, saying the same thing about that. We had a situation too where a husband and wife owned a property, and the husband signed the wife's name. The agent, our agent owner, witnessed the husband signing the wife's name. And he actually witnessed on the contract beside the wife's signature as he saw the wife, as though he saw the wife sign the contract. Folks, that little moment of indiscretion cost that agent owner $5,000 deductible on our errors and omissions, and we won a lawsuit over that. The wife decided she didn't want to sell. She said she never signed. You can imagine what the rest was like. Just don't get caught doing that kind of stuff. That's foolish. No need to do it. If a husband signs a wife's signature, you don't need to be a witness to it. You don't need to be visually seeing it, or certainly not signing that you saw it. Okay? Now, a lot of people say on this contract that if they're representing a buyer as a customer, excuse me, not representing, but they have a buyer who is a customer, there's no place to put that on the offer, on the contract. Yes, it is. If you have a buyer who's a customer, then you're representing this buyer as a sub-agent of the seller. If you have a customer, you are then representing the seller. You're not representing the buyer. So be careful. I mean, you can put that in there. You don't have to write something else, okay? Escrow agent acknowledgement. Ooh, I've got some horror stories on this one too. Do not sign that contract paper saying that you have the earnest money unless you actually have it. Okay? If you have a buyer that's going back to Ohio and they're going to send the check back, and you know they're good for it. They're going to back and transfer funds, and they're going to send the check back, and you know they're great, so you go ahead and sign it. And guess what? If they don't send that back, guess who coughs up the earnest money? Yeah, you, the agent owner. Because we at Agent on Realty, we're telling you not to do that. So the company is not going to back you up there. Do not sign that you have earnest money unless you actually have it. If you've got a check, money order, or certified funds, then you can sign saying that you have it. Okay? Our Addendum A, please always use Addendum A. It is provided in order to assist you in remembering items for your contract. Okay, Lisa's asking the question, if another company wants to keep it as a photocopy, okay. Oh, keeping the earnest money, yes. I mean, yeah, because you've actually received the earnest money and you've passed it on to the other company because they're holding it. So a copy of the check in the folder is great. You're not signing, though, the contract in that case. The other company, Century 21, Carolina 1, XYZ Realty, whoever is holding it is who would sign that part of the contract, not you. Okay? Addendum A is provided for you to assist you in remembering things that you should put in a contract. Maybe you out in the woods selling a house or selling acreage or something, and you're writing an offer on the hood of your automobile, and you can't remember the verbiage of what to put in. Maybe this is a backup offer to another offer that's already in. You can't remember exactly how to verbalize that. Your Addendum A has that in there for you. You don't have to remember the verbiage. We've already done that for you. And by the way, this has been approved by an attorney. Not a problem. And another example of this is the home inspection at the sole satisfaction of the buyer. Can't emphasize that enough. If you're representing the buyer, you need to do that. I see contracts where people put in there representing buyers. They'll put buyer to have inspection. Okay, that's great. The contract already gives them permission to have an inspection. So what do they want? What that other agent is generally meaning is that it's subject to the approval of that buyer, but they don't say that. Be careful of the verbiage you use when you're writing your own contingencies and your own addendums. Be careful that you're saying what you intend to say. I could go on and on telling you all these examples of bad situations. People write things like, it's subject to the parents approving the contract. Okay, parents. Are we talking about 4 parents? Are we talking about 2 parents? Are we talking about 1 parent? Well, if it said parents, it's probably at least 2, unless somebody doesn't understand the English language. Are they talking about doing it within a week? Within a year? What are they talking about? Be specific. Make sure that somebody else, when they read it, they can understand what you meant to say. Okay? This is very, very important. Covenants and restrictions. That is in the addendum. the buyer needs to approve the covenants and restrictions. And so often, I hear people saying, well, the attorney's going to get them a copy of that at closing. Well, even if the attorney does, which a lot of times the attorneys don't, but if the attorney does, closing is too late for a buyer to find out what's in the covenants and restrictions. I've told this before. A lot of my Johnny Dodds agent owners have heard this, but for the others, we had a situation in Goose Creek years ago where the agent owner wrote the contract, knew they were supposed to use the addendum, knew they were supposed to make it contingent upon the buyer approving the covenants and restrictions, but did not do it. The buyer bought a condo, closed on it, went home that night so excited. He rode his motorcycle home. Motorcycle, his only mode of transportation, and our agent knew that. He got a knock on the door that same night saying, "Did you realize you cannot have motorcycles in this neighborhood?" He had no clue. Guess what? The end of that story? We had to buy that condo back. That buyer could not live there. He had no other transportation. Had this subject to the approval of the covenants and restrictions been in the contract, it might have still gone to closing, and the same situation might have happened, but we would not have had to buy that condo back because he had the privilege of approving those covenants and restrictions. It was a buyer's responsibility to read those and approve them. So be sure that you include that. And don't tell me, hey, look, that subdivision doesn't have any covenants and restrictions. I beg to differ. I'll almost be willing to make a bet with you, if I were a betting person, that every subdivision out there has some sort of covenants and restrictions. They may be very small, very limited amount, and very lax, but they have some. Another good example is, Boyd and I did this years ago. Years ago. I've learned a lot over the years. We bought a house that was right behind our Mount Pleasant real estate office at the time. This was before agent-owned days. Our idea was that we could expand our parking lot and expand our office right into that home that's back there. What we found out when we started to do that, we bought it, we closed on it, and when we decided to move that direction, oh, no, you can't do that. It's against the covenants and restrictions of the neighborhood. That property, even though it backed up to our commercial property and it backed up to the frontage road, could not be commercial. Okay? You have to be careful about covenants and restrictions. Learn from Mama Liz. Learn from my experience. Okay? Does anybody have any questions or anything that they'd like to propose to me? That's pretty much what I intended to cover. All right. I don't see any being typed. I think I answered everybody that put them in there. So no need to keep y'all around for nothing. I enjoyed it, and I hope you got something out of it. And we will, oh, no questions, okay. We'll see you next time. I'm going to be putting out a schedule of all the seminars, webinars that are coming up, and that schedule will be going out today. So watch out for it. We have some interesting things coming down the pipe. Thank you, and you have a wonderful day.